Really happy to be here, Paul. Thank you again for inviting me to speak to this wonderful group of parents and caregivers and loved ones. So, as Paul mentioned, my name is Laura Brancato. I am an attorney currently in private practice. I've been practicing in the vulnerable client space for just about 22 years now. And right now, I run my own law firm, which focuses on vulnerable client specialties, specifically working with families of any vulnerable individual. So that can be anyone who's in the intellectual or developmental disability community, people who have long term mental health challenges, substance abuse disorders, eating disorders, gambling addictions, all the way through to cognitive impairments caused by dementia or other traumatic brain injuries. So, as a general measure, my practice really focuses on clients who don't function in the world the way that a neurotypical person might. And, and because of those challenges, needs more support either from an estate planning perspective. I do have some clients who are involved in the criminal justice system, so I represent them there. I work with families who are in crisis in the family court system with orders of protection and other court-based litigation. But the primary part of my practice really focuses on two primary areas, being guardianship or conservatorship, as you call it in Connecticut, and the mental health law, specifically assisted outpatient treatment. So, knowing that most, if not all of you, are based in Connecticut, I'm going to try to speak about the legal landscape here from a 1,000-foot view, because as you can imagine, every state in the country handles these types of cases differently. But there are commonalities that we can find state to state, especially in the tri state area. And so I want to start by just giving an overview of the legal landscape so we're all thinking about this from the same standpoint. So when you have a loved one who is not maybe self-sufficient or not functioning at an optimal level, you may have had legal consultations where you've been told there's nothing you can do. There is no legal landscape that addresses this. There is no law that pertains to this. You can't force treatment. You can't force compliance. You can't force outpatient compliance with, medication protocols, things like that. And that historically has been true. However, if you use the laws that exist both in Connecticut, New York, Pennsylvania, New Jersey, Florida, Texas, California, if you use the laws creatively and you use them in a way that's meant to support a beneficiary or a loved one who's struggling, you actually can come to a good legal result. The problem is it's not a simple or straightforward legal result. And most lawyers want to be able to tell you, I am an estate planning lawyer. You're going to come to me. I'm going to complete a set of documents and this case will be finished. Or I'm a guardianship lawyer. You're going to come to me. I'm going to get you a guardianship and the case will be finished. But that's not often the way our loved ones live, right? They live very variable lifestyles. They go in and out of stability. They go in and out of capacity. And so the legal landscape is not quite that straightforward. It's actually much more complicated than that. So the legal solution has to be flexible and it has to be varied so that it meets the needs of the person in the place where they are. Because one common theme that we find across all legal landscapes is that if you're going to use court intervention or oversight, it has to be tailored. It has to be narrowly tailored to the needs of the person. So Paul mentioned at the outset that I would specifically be talking about assisted outpatient treatment. So let's start by just defining what assisted outpatient treatment means. Now, for most of you in Connecticut, you probably may not have much of a background here because Connecticut happens to be one of the only two states where AOT, as we commonly refer to it, has not been implemented as a mechanism for medication oversight. But for those of us in states where it is implemented, assisted outpatient treatment is a mechanism through which a person who has a history of non-compliance with meds can be held accountable in an outpatient setting. So for most families, as I'm sure many of you know, you're struggling with the cycle of inpatient treatment, outpatient oversight, and often the outpatient oversight falls to the family or the parents or the caregivers because once a person is no longer in an inpatient setting, Their medication compliance is somewhat up to them. And we can all, as their family or loved ones, encourage and hope that they're taking their meds. You might often feel like a nurse where you're constantly scrutinizing were the meds taken, or are you responsible for giving them? And it creates a very difficult dynamic among an individual who's struggling with their stability and their family members, where often the person feels infantilized or babied or just overburdened by the constant oversight by a family member, a friend, or even a treating psychiatrist. So, what the law envisioned in New York, we also call it Kendra's Law, which originated from a very unfortunate case of a person who had been suffering with schizophrenia for most of his life, who had been released from prison in New York and ended up murdering a young girl whose name was Kendra. And the concept was that once this person had been released from care, that the state did not maintain oversight into his medication protocol. And so the law was enacted in New York around the same time it's been enacted throughout the country. And I would say that, Kendra's Law, the main focus is to try and keep a good amount of supervision in place so that medication compliance kind of gets taken out of the equation. So the way it works in New York, also in New Jersey, and also in Pennsylvania, is if a person has been in inpatient treatment 3 times within the preceding 18 months, and if they have shown or evidence that when they're released from treatment, they are medication non-compliant, the treating facility, upon the 4th release, can go to a court of competent jurisdiction and seek an AOT order. The order is basically an outline of what the treatment protocol should be, and it includes medications that should be administered, how they should be administered, injectable, oral, liquid, etc., and in what dose, and also can prescribe other things like whether the person should be drug tested, what types of drugs should they be tested for, how many times a week should they attend therapy, should the therapy be group session, should it be individual, should it be both, should the therapy be with a psychiatrist or a psychologist or both. And there is a treating psychiatrist appointed in every one of these cases who oversees the treatment protocol for that individual. And that order takes effect upon the person's release from either medical institution, a jail, or wherever they might have been housed prior, and it covers them during the time that they live in the community. So that assisted outpatient treatment order is monitored by the county in which the person lives. And each county has their own AOT teams comprised of psychiatrists, psychologists, nurse practitioners, and social workers. And in varying groups, they go out into the community and visit with everybody who's under AOT supervision. How frequently they visit is determined by the order itself. It might say for the first 6 months or the first 3 months, a weekly visit. It could say a bi-weekly visit for people who are severely ill. It could say a once monthly visit, and that can change over time. And the way the AOT team works is they become the party legally responsible for assuring medication compliance, thereby taking that burden off of a family member or a caregiver or even staff at an outpatient treatment center, and kind of centralizing the oversight of care with a specific team that is specially equipped to address medication compliance. One of the ways that the AOT team monitors medication compliance is they might be the administrator of the meds. So, for example, for clients who are on monthly Abilify or who take a monthly injectable, the AOT team administers the meds. So they are the team that goes into the community and makes sure that the meds are actually administered. For clients who are taking daily oral medication, there are many ways that the team monitors medication compliance, but one of the most common is that they will do blood draws or labs so that they measure whether the patient has a therapeutic dose of medication in their system. And based upon what the dosage is and how frequently the person should be taking it, they extrapolate to determine whether or not the patient's actually swallowing the meds. Are they spitting the pills out? Are they failing to take them all together? And in that event, if the person is not compliant with the medication protocol, a different set of factors goes into place. Now, for many of you, probably the biggest struggle when a loved one goes off their meds is what to do next. You probably all are very well trained to see it. You don't need a medical license. You know, as soon as someone in your orbit stops taking all of their meds or voluntarily decreases doses or does other things. AOT teams are similarly equipped. So they will start to notice subtle changes long before we might reach points of psychosis or other problems. And what they are empowered to do without further order from the court is to bring the patient back into an inpatient setting for 72 hours, to have them assessed, to have further labs done, and potentially to have an application made to the competent court of jurisdiction to have that person held a longer period of time. And all of that happens without any further legal intervention by the family, by the treating psychiatrist in the community, by the social worker. It happens reflexively within the AOT program. And the reason that that's become such a crucial part of wellness is it makes it less about caretaker or parent versus child or versus spouse or versus sibling, and makes it more institutional in a sense, in that there are just boundaries that can't be crossed. There are very healthy borders that are set by the AOT team. If you don't take your meds, we're going to bring you back to the hospital, and the hospital team is going to re-administer, go back to court and get the meds. And so your compliance is part of your discharge plan. And if you're not in compliance, we're going to keep bringing you back into this scenario or into this medical setting until you comply. It cuts down a great deal, in my experience, on the anxiety parents feel about, do we call EMS? Do we call the police? Those fears families have about what happens when the police get involved. If your child or loved one is not having a great time and they're being violent or aggressive, are they going to get hurt, shot, tased, whatever? It takes that temperature down to a much more therapeutic level. And the people who are transporting your loved one back to the medical facility are medical professionals and not emergency service workers. The AOT team may be assisted by the police or fire department or EMS, depending on the circumstances, but they will always be on the ground at the site when that's happening, rather than this happening kind of in a vacuum and you're not sure who is going to be responding to your 911 call. So in my experience, AOT has become a vital part of an outpatient treatment plan. Even for clients in intensive outpatient treatment, AOT, or the thought of knowing that these things are going to be, implemented, whether the person is in agreement or not, helps to normalize that potentially medication is going to be a part of their everyday lifestyle for the foreseeable future. And that usually buys us enough time to get the person into a more stable environment so that we can do better long-term mental health interventions, better therapy, maybe even better testing to understand what might be driving psychosis or unwell periods. AOT also can help significantly in the substance abuse space. So, for example, if you have a loved one who has been abusing Oxycontin or has been abusing heroin or meth or something like that, the AOT order will permit the treatment team to test for those substances in addition to prescribing or overseeing psychotropic medication. And what that does, again, is it takes the family, it takes the caregiver out of that policing role where they need to be overseeing everything that's going on in the person's life. Because if the drug screens are coming back positive, the AOT team similarly has the right to bring the person back in for appropriate treatment, whether that's mental health treatment, substance abuse treatment, usually both, and without further intervention of the court or the family or anyone else. So it's a mechanism we use when we try to establish more of an arm's length way of working with someone who's struggling with addiction, especially when they have a comorbidity with mental health. Because what I've seen in my practice over the last 15 years and what I saw in my time in the DA's office in the 7 years I was there is just that at times the family dynamics heighten and complicate the opportunity to get somebody treatment, the opportunity to help get a person to wellness and stability. because there are feelings of shame, there are feelings of embarrassment, there are feelings of frustration, and that's shared among everybody. There are, some relationships unfortunately are codependent. There's codependency going on between the person who needs help and their family members. There's a lot of, especially when siblings are involved, a lot of difficult feelings, a lot of, grievances, aggravations. I see it in the courtroom all the time. Siblings who are talking about drug abuse from 15 years ago because they still haven't totally healed from that process themselves. So I do think that AOT has a way of giving the family members kind of an arm's length oversight where a county or a court is responsible for overseeing outpatient compliance. And many states are leaning on this process now to avoid the very unpleasant consequences of people living unhoused or mentally ill on the street, in the subway, in the churchyard, in all these other places, especially here in New York City. We're seeing an increasing amount of pressure to consider as many people for AOT as possible to avoid subway assaults, to avoid random stabbings or shootings. I'm sure you only have to read the paper to see what the situation here is in New York City. So the government is more increasingly relying on this as an alternative. It's not the only alternative. And sometimes we use AOT in conjunction with other programs. Sometimes we use it with guardianship. Sometimes we use it with really good estate planning or the appointment of a trustee or the use of a NAMI or nonprofit to support the family. It can be a mosaic, actually, of different programs that meet different needs. But we have found a lot of success in AOT because it systemizes and makes more regular this idea that for certain people, medication is going to be a part of their overall daily lifestyle. And a decision about whether to stay on or go off is not going to be tolerated by the county, by the Department of Social Services, or by the medical community. And we have seen some very positive results for individuals who have just struggled to stay stable. And so it cuts down on costs. As I'm sure many of you know, this is an exceptionally expensive journey to go on, in and out of treatment facilities, in and out of hospitals, private doctors, medication. So AOT has also been an economic benefit because you don't pay for it. It's a county resource paid for at the state level. And so therefore, it's not another private pay scenario. You don't have to employ an interventionist or a case manager. This is something that's paid for and all of the therapy included by the county and state in which a person lives. So it becomes also an economic factor for many families. The AOT order can last anywhere from 6 months up to 2 years. For some people in limited circumstances, it can be a lifetime order for people who've had significant mental health hospitalization or history. But generally, the orders are 6 months in length. At the end of the 6 months, the person is evaluated by the treatment team, and then the treatment team makes a recommendation to the court whether to request to continue the AOT or whether to terminate it. I would say most people, the average length of AOT is about a year. We do have some people who are on 2 years or maybe 3 years. And sometimes we have a 6-month order here and there, but the most common is about a year's time. And then after that, if you come off of the AOT program and then come destabilized again, the county can always seek that order to be reinstated. So you never lose out on the opportunity to do it. There's no timeline to do it. So we encourage clients to think about it as a mechanism. Now, I know if you're living in Connecticut and your loved one's in Connecticut, as I mentioned, it's not available. However, for those of us, I live in Westchester, right? So right there on the Connecticut border. If you move into New York, Westchester, Orange County, Rockland County, AOT would be immediately available. So it is a remedy that, depending on where you plan to house or to support a person, could actually be available. It's also available in all the other states that border Connecticut. So there's no shortage of ways that AOT could be implemented pretty readily into the lives of your family members or your loved ones or your children. So it's not a far away thought. Paul and I have had a few conversations in the hopes that Connecticut will soon consider it. It's been on the agenda multiple times. And I think that ultimately what will drive the approval will be the success rate of other states and other counties who can evidence just how great a benefit AOT has been to those of us who work in these communities who just want options. From my perspective in the legal field, I just want as many options available to me and my clients and their loved ones as possible. I don't want anybody to tell me something isn't working or isn't available, because we know there's no one size fits all solution here. So what works for one person may not work for another. I just want to create as many different opportunities as I can for my clients to support loved ones in varying ways. And that's why I think AOT should be a very important tool in the toolbox. That's a lot of talking. So I'm super happy to start answering questions. If you have specific questions, we can also talk a touch about how it intersects with guardianship, if that's of interest, or conservatorship to people. But I'm happy, Paul, now to take some questions if there are any.
Yeah, and I'm happy to help you see who might have a question, but just so I mean, you've summarized here that this is actually improving outcomes because of all the family dynamics going on that prevent people from getting access to the care that could be needed.
Right.
And then it
Right.
could save money. I mean, it's just, I think this is a great discussion for me. I just see through our parent support group meetings, many parents having to deal with psychosis now with the legalization of cannabis. And so I think you've given us pretty good examples of, a pretty good specific rundown. And I think if somebody wants to unmute to ask a question, I think we can just go that route. So Kia, if you have a question, do you want to just ask it, or do you rather have me read?
Oh, sure. No, I can ask the question. Thank you so much, Laura, for all of this great information.
Sure.
So just two questions. You mentioned that the eligibility to initiate an AOT order would be inpatient 3 times, correct?
So
Over.
the guideline is 3 times within 18 months. Every state has it slightly different. New York standard is pretty common. That's the New York standard. There are exceptions to the rule, but generally we're looking for a person who's cycling in and out of inpatient treatment and then coming back in for medication noncompliance.
Okay, awesome. And then in terms of the definition of inpatient, does that have to be a hospital setting, or can it be they were inpatient at any type of mental health or
Any
facility?
type of mental health facility. It could even be a jail. Sometimes we have people who have been in prison and unfortunately not being treated for their mental health condition while in jail. And the jail or the district attorney's office can even seek it as a measure of their parole or release. So there are many different ways that the AOT can be initiated.
Okay, and then my last question is, you mentioned that the treatment program that they're in on that 4th time of being inpatient can initiate the order, but can
Yes.
a family member initiate the order through the AOT team in their county?
Yeah, so basically in New York, the way the statute is written, and if you want to look it up, there's plenty of information. The New York AOT comes to us under our mental hygiene law, Article 9 statute. So if you Google mental hygiene law, Article 9, you will find that there are 3 parts to that law. 2 of the parts many of you are likely familiar with. The first part is retention in a medical facility over a person's objection. So when that 72-hour hold or that 2-week hold you might be familiar with. The second part of that is treatment over objection, which is when a person is in a medical facility, they're being held, and doctors want to administer certain meds, they refuse to take them, go back to court and get a second order to treat over objection, meaning injectables, solubles, whatever that is. And the third part of Article 9 is the assisted outpatient treatment arm. And so AOT can be initiated by a facility. It could also be initiated by a parent. It's a little harder. So this is what I usually do. And I was thinking about this call tonight, Paul, because I had a consultation just last night with a family, and I'll give you the details because I think it will ring true. A young man 25 years old, doing very well in his early career, has a psychotic break. That happens a few times. He's using a lot of prescription medication, specifically Xanax and Adderall and other things that are aggravating whatever the underlying mental health issue is. So he's cycling in and out of mental health facilities, namely in New York City. And unfortunately, downtown New York City, we don't have very good inpatient care down in the midtown and downtown area. So he happens to be in a hospital that's infamous for discharging people without real plans. So my advice to the family was, since he is in inpatient care, he's already being held under an order, and he's been at that place 3 times. You get on the phone with every single person that will listen to you, every social worker, every psychiatrist, call up the legal department, I'll write a letter, and you just say the words AOT as many times as you can. I want you to seek an AOT. Get me an AOT. He needs assisted outpatient treatment. He needs supervision in the community. And you become that squeaky wheel. So technically, could the parents prepare a petition through a lawyer like me and march into court? Absolutely. Do the medical facilities have a better leg up because they're in court once a week with those same judges? Absolutely. So what do we want to do? We want to put pressure on the medical facility to say, discharging my son is not safe or appropriate without AOT because he's a danger to himself or to other people very shortly after his release. And so I want you to seek an AOT. And you just say that, you say it in writing, you can write letters, you can write emails, however, and this applies whether you're getting that bizarre message from the facility about HIPAA or not. If you're being told your loved one doesn't want to speak to you, they won't sign the request for information, I'm not allowed to speak to you. I know many of you already know this. Always keep in mind that that does not prevent you from speaking to them. So you can speak to them as often as anyone will get on the phone with you. They may not be able to share anything with you. You may not be able to attend a discharge planning meeting, but 100% HIPAA is not a blockade to you providing relevant information. And a lot of times, depending on where your loved one is hospitalized, they may not have the full breadth of their medical or mental health history. So you may create a document. I have a lot of clients do this, that we just reproduce, where you just keep a running list of everything they've been through, every medication they've been on. I know most of you could probably recite it by memory, right? Everything that you've tried. So that when you get to that new social worker or that new psychiatrist, you never know who's going to be the difference maker. So you just keep providing the information. And in every communication, you say, I want AOT. And this way, they're on notice that that's what you think the best standard of care is for their child. And more often than not, they'll seek it because it's no skin off their back. It doesn't require them to do anything other than seek it. The monitoring happens outside of the hospital. So it's usually a win for them because you're not asking them to do anything other than file the paperwork. The oversight's going to happen outside of their control. So there's usually not a great deal of reluctance to do it that way. So the technical answer is parents can be petitioners, but from a practical standpoint, it's much easier, faster, and more efficient if you put pressure on the medical facility so they become the petitioners.
Thank you so much. That was helpful.
Yes,
Thank you.
of course. My pleasure.
Laura, can I ask you this? If you described an AOT as being somewhere between 6 months and 12 months, there's clearly a protocol that has to be met to get in to begin. But if somebody this sounds like maybe a pretty common use case, 6 months, 8 months in, the order expires, the person that was benefiting from the assistant outpatient program relapses back to their normal pattern of behavior. Do they have to go back in 3 times again and then reapply?
No.
How does that work?
No, once you've been on AOT, you're predisposed to be subject to that order again. And your treatment records from your previous AOT are all available to the AOT team in your county or any other county if you've moved places. So that's also very relevant. So a lot of times, Chris, the way that it works would be The AOT team is usually, my experiences in, I work in many different counties in New York, so I've had experience across the board. They are very cautious about taking somebody off AOT. If they feel there's even a modicum of a possibility that they will not be compliant or that they lack insight, which is, the biggest dragon we have to slay in this illness, this schizophrenia illness, is this persistent lack of insight, this persistent lack of understanding about the need and the necessity for medication. If they feel like that's at all present, they will go to court and extend. So they happen in 6-month increments. So it will never be 8 months. It'll be 6 months, 12 months, 18 months, 2 years. And so if they feel during the reevaluation process, the person still lacks an understanding or lacks acceptance into why they need to take meds, they often will not lift that order. They will go to court and ask for that extension. But yes, if you come off of AOT, I've had clients who've come off. I had a client who lives up in Columbia County, did very well on the program for 2 years. The program said, okay, I think you're in good shape. He came off, he stumbled out of the gate, and they put him right back on. So you don't need 3 more hospitalizations to qualify at that point.
Hey, Laura, it's Lisa Tuttle.
Hi.
Hi, how are you?
I'm good. How are you?
Good.
Good.
So I have a question. So right now, Aiden is in Westchester, as you know. If somebody were to put their kid in like a rehab, sober house living type place in Westchester, even though they live in Connecticut, would that be sufficient to then do an AOT in Westchester?
Yes. He is residing. He's physically in Westchester County. He can be monitored by the Westchester County AOT team. Yes.
Okay. And once he's on an AOT, let's say in Westchester, if for some reason he needed to move,
Right.
To a different part of New York, like they transfer the AOT to the new team?
They do. So as long as you're within the state or even interstate with a state that has AOT, your AOT order will be transferred. So in New York, this happens pretty frequently. We have people living in the city in transitional housing, then they move up to Rockland County, and there's an inter-transfer that happens from team to team, where they apprise the other team of what the circumstances are, they send the records, and the treatment team and the order gets sent up to the new county, and then they get assigned a new psychiatrist under that AOT program, and then that person monitors their treatment, that new team.
Okay. Thank you. And last question. So for those whose kids are in Connecticut, short of putting them into a treatment program in New York or Massachusetts or Rhode Island,
Right.
What are the laws within Connecticut for being able to do any kind of
So it's a good question, Lisa. You have a more liberal guardianship or conservatorship statute than we have here in New York. So the Connecticut conservatorship statute does give a conservator, if you can get it, and conservatorship is a little bit of a different legal framework, right? Conservatorship has to do generally with a person's finances, how they manage their money, getting control of whatever resources they have, which can be a very important part of dealing with addiction, right? If you can cut off the source of money, you might be able to impact the use and how the person's accessing substances or alcohol. So guardianship or conservatorship can be a very important part of that process. And in Connecticut, when you get conservatorship, you do have the right to make certain medical decisions about treatment that we would not be permitted to make in New York. In New York, we have a baseline prohibition. Guardianship orders cannot be used for mental health or addiction treatment. You cannot use a guardianship order to force somebody into treatment. You have to go through that Article 9 statute that I just talked about, where you get first treatment, then you get treatment over objection. You cannot do it with the guardianship order. But in Connecticut, you have a little more leeway. Other states where you have a great amount of leeway, Florida, a ton of clients who we try to get to Florida just for the purpose of getting them in. Florida has a very liberal law on treatment for addiction and substance and alcohol that New York just doesn't have. So sometimes, Lisa, we're looking for an intermittent hospitalization or inpatient placement, and then we look longer term for where is the stabilizing, long-term inpatient or outpatient treatment. And we might look for a jurisdiction with AOT at that point. But if you're in an acute crisis, then conservatorship, depending on what the circumstances are, might be a good fit. But otherwise, Connecticut really, this is a big missing piece in your statute because it's working in other counties. And I can't really understand what the argument against it would be. Paul's given me some, none of them are super persuasive to me that, passed to him by others. But, I think that other states are leading the charge here and finding other ways to get things accomplished in this space, knowing that the biggest issue that we all face is this just horrible lack of insight that's happening with our loved ones.
Thank you, Laura. That's
Sure, of course.
actually, I have one more quick question.
Yeah, of course.
So, as you may have heard, Aiden's finally responded to his antipsychotic, and he's doing well, and he's going to work and has a job. And the question now is, does he look too high functioning to get and to qualify for an AOT?
No. So AOT, again, is about oversight. If he were not in this structured program, or if he were not, given these opportunities, would he be medication compliant? So it's not about the same standard of dangerousness that we think about when we think about inpatient treatment. And again, in New York, we're kind of in this, I hate to use this word, but almost a renaissance in terms of how we're looking at mental health because people are afraid. And though I really hate the presupposition that everyone with a mental health issue is dangerous in some way, it is playing to our benefit in the courtroom because judges don't want to make a mistake. They are erring on the side of caution where historically they had been pretty liberal, even in the city, even in Manhattan and Brooklyn and places where we would have no success with the court. We're having greater and greater success because there's just greater awareness that with certain types of serious mental illness, the lack of awareness is a symptom. It's not a characteristic of the human. It's not about their intelligence. We're getting past this idea that just because someone is above average intelligence, that means they can't be psychotic. We're starting to understand better as a legal system that actually is a feature of the illness and not some random side effect, and we're looking past a person's intellectual ability to argue their way out of a conversation and instead looking at what I was always hoping we'd look at, which is if nobody were to support this person, how would they function? And the answer is they wouldn't, right? And so we're having that conversation more readily with the court to say we cannot keep sticking our heads in the sand. We have to be addressing these issues as the person presents. And so my hope is that we'll keep having those conversations because that's what really drives better outcomes.
Gosh, we can't get it in Connecticut soon enough.
Yeah, for sure. For sure. But I do think that if you are working with the right professionals, the right mental health party, things like that, you can still piece together a pretty comprehensive plan in Connecticut. I just think that, from a long-term outpatient perspective, for those patients who just persist in and out of medication compliance, it's really been the only answer. And it's the only, I should have said this at the outset, it's the only civil statute in any state that can monitor medication compliance. There is no other way. There's no other alternative to that program. There's nothing like it.
I don't know about New York State or Connecticut as far as what is happening with incarcerated individuals. But it sounded like in New York State, because parents do sometimes go, "Oh, I'm so glad that he was taken away. He's literally in prison," because they were at wit's end. There was nothing else for them to do. And what are New York State prisons now that there's AOT? Are they getting more into helping people?
I think it just Yeah, I think, Paul, it just depends on what jurisdiction you're in. You know, with the advent of treatment court, which was supposed to be the answer to a lot of these problems, not just incarcerating people, but putting them before a specialized judge with specialized caseworkers who could help direct people to treatment instead of to jail, we thought we would see better outcomes. But the reality is that we're still very short on funding for good mental health treatment programs, for good programs, period. And so, in a sense, we are diverting more people out of prison into programs, but we're not seeing long-term success. And it's because the programs we're putting them in are not supportive enough. And then we're not supervising them when they're out of that, protocol. So I think we still have a lot of work to do there. I know in New York, it was a big fight during the budget season. This year, it's still ongoing. The budget has not been passed in New York. And so it's going to continue to be a fight between service providers, between people who are trying to, do the best they can within the system to make do with what we have. We lack it, like as in every state, inpatient beds for people, longer term inpatient beds. So we're still funding these short term or outpatient centers when we really need more long term hospitalizations for people who just have pervasive issues that can't be managed in 2 weeks or 4 weeks or 6 weeks. Some people really do need that 4-month oversight. They need MRIs, they need ongoing medical treatment. So until we kind of normalize again and take away that concept that asylum or longer term placement is abusive or should be avoided, we're not really going to make a ton of progress. So we're hoping that the advocacy efforts lately will bring that to light again to say, this is not something we should be afraid of. Should we put everybody into an institution for 4 months? No. But are there some people who need a longer look? Yeah, especially in the wake of the marijuana crisis and all the different things that are arising now because of these unknown, psychosis, the origins of, unknown origins, So until we start expanding our mindset that way, we're always going to be chasing the problem instead of proactively addressing it.
Right.
Hi there, Laura. Thank you for your information. It's really helpful to hear that.
Sure, sure.
I do want to point out for the people on this call who are mostly based in Connecticut that most AOT programs across the country and the other states do not have the AOT programs directly providing the medication. It really mostly is done with care teams that they're already associated with. The AOT process and program is overseeing that is happening in most other states. New York is kind of unique in that way. So I just want to make that clear to folks on the call. Would you agree, though, Laura? I know that you're saying that, yeah, it's not working great for people that are coming out of prison or potentially getting into a criminal mental health court and diverted because there aren't adequate resources. But would you agree that AOT generally is seeing a reduction of those people who are in the AOT programs ending up getting in jail or in prison in the first place? You're reducing incarceration
100%.
and arrest.
Agree with you.
Yeah.
100%. Yeah. And it's also, as many of you know, the number of times a person cycles through these illnesses, the number of times they're traumatized by being, brought into an ambulance by EMS or forcefully by police, or every time that happens, you create a scenario that makes it even harder for them to come back to baseline. So if we can just reduce by 1 or 2 the number of times a person cycles through the process, we're going to naturally just see better outcomes, because we really can't underestimate the trauma that's involved in this whole process. You all feel it in your role as caretaker, a loved one, parent, and the patient themselves feels it too. And we haven't really, I participated in a task force with New York State last year called Trauma Impacted Representation. And it was about this concept that even just being forcefully detained when you're in a psychotic state in a subway station or in a restaurant or at Rite Aid, that whole process of being handcuffed and brought to jail and put in Rikers for a few days while you wait for legal aid, that whole process is so disruptive that, we're kind of creating the problem. We're creating the monster and then trying to solve it after the fact. So if we can even just reduce by 1, Leslie, the number of times a person cycles through that place, we will naturally just see better outcomes.
Absolutely agree. Thank you for saying that.
Sure.
Thank you. And I'm going to stop asking questions so others can.
Laura, I just had another question. Lisa again.
Sure, Lisa. Yeah.
So what if the psychiatrist who is assigned to your AOT, like, do you have any input to what meds they use? Do you get to have, if you're concerned?
It's a really good question. It's a really good question. So yes, certain AOT teams are more responsive than others when it comes to how the treatment protocol will be written. Probably one of the chief complaints about AOT is that you don't often have the insight that you would hope for with the treatment team. And that could be for a variety of reasons. But yes, generally the AOT team is working in conjunction with all of the other community supports to support the patient, because they recognize from an AOT perspective, like most providers do, that the family is the most crucial part. Whatever other structures the person utilizes is the most crucial part of their stability, and they will include family to the extent they can.
Thank you.
Laura, I've heard the term decompensation. Is that kind of what you're referring to in cases where trauma is increased through, multiple police visits and things like that? Or what is decompensation?
Yes. Yeah, so that's a way that I try to typify, or I try to quantify that each time, the brain is subject to trauma, that there's further decompensation in terms of the resilience that we know that the studies show that your brain is just not as resilient. And that would be true in any circumstance. That's true of head injuries. That's true in football. We're always talking about the brain's ability to rebound and be resilient. We're talking about that in this setting as well. That each time that these things happen, that your brain is just less resilient. It's less able to recover from, whatever it's been through, especially if you're going on and off significant medication. You're putting your brain through a great deal of stress. So if we can limit that back and forth, even just by one, we will have better outcomes. Assuredly, we would have to.
And in terms of costs, yeah, I mean, in one way, maybe it's because the state would be providing the resources, but even if you just look at it from the standpoint of, because it's being presented, AOT is being presented as the option other than inpatient. And we know inpatient is much more expensive, so it's just less costly because AOT in general for the state or for individuals, it's just less costly.
Right. And we also know, Paul, that most clients don't want to stay inpatient, right? What is everybody asking as soon as you visit? They want to know how much longer. They're always measuring how much more, how much longer, how much longer. So this is another stretch goal of, look, we want you to be stable in the community, and we're going to provide you with every opportunity to do that in an outpatient setting, because we too want you to return to regular life. We want you to have these, the life independence, the autonomy, the agency that you're looking for. We just need to do it in a safe way. So this is kind of meeting that need as best we can.
Laura, I've got another question. I don't want to monopolize you. Does anybody else have a
it's okay.
question? Because I can keep asking, but if anyone else has a question, please jump in. Okay. Well, so I've got a question about, do you ever have a situation where, obviously I'm thinking right now of Aiden, where you get someone to agree voluntarily to AOT? Like,
yes,
is there a way
all
to
the time.
appeal? Yeah. Okay.
All the time. And just the way that I said it to you, which is, if you know that that's the way that you can be, moving out of an inpatient setting into a more autonomous scenario, we often will have people, who will volunteer and say, yeah, I'll do that. And, or they can even if they don't volunteer for the first order, after they're under the program for a certain period of time and it's working, they can consent to extensions of the order. You don't always have to go to court. If they agree and the treatment team agrees that the continuation of the order is in their best interest, they can just consent in a signed document, and then the order continues. So it's not always necessary for it to be an adversarial process.
Yeah. Okay, great. So we can
Yeah.
say to Aiden when he's like trying to get out of his current sober living, well, okay, as long as you agree to AOT, we will support you in,
Yep.
Okay.
Absolutely. We can have that conversation anytime.
Okay. Thanks.
Yeah, of course. Lisa knows how to reach me. So, and I'm sure Paul will give
Yeah, that's
all of
why
you
everyone
my,
else.
my
Yes,
email or phone number. Please feel free.
Yes, I know how to reach you, and I got to admit, you have a beautiful background on your
Oh,
Zoom
thank you.
screen. This
Yeah,
is just
I'm on
look at that.
yeah, can you see? I'm on the Hudson River at an event. So I'm doing an
Wow.
advocacy event actually with the budget season in an attempt to try to get the state to consider some of the longer term mental health beds that we so desperately need. So we'll see.
Yeah.
We bring people
Well,
to beautiful places and then try and twist their arm, you know?
yeah. Any more questions? One more question before we go. Leslie, do you have another one?
I do. Laura, what would you say? There are people, one of the reasons that it has not passed in Connecticut is there are a lot of powerful voices in Connecticut who are really vehemently opposed to involuntary treatment for any reason. And most especially, they're opposed to involuntary inpatient treatment because of traumatic experiences they have experienced themselves.
Yep. Yep.
And this is where I think it is important to differentiate out that different people end up having involuntary inpatient treatment, and that it's very valid and true that trauma happens in those settings, unfortunately, way too
100%.
much.
Agree.
So I spend a fair amount of my time working to reduce that trauma, right?
Right.
But what would you say to people who are perfectly fine with leaving people to die on the streets, with their civil rights to refuse treatment for an illness that they have no idea they have, or to be incarcerated, or just to let them die slowly, painfully? What would you
Right.
say to those people who oppose it so vehemently about
So,
AOT?
yeah, so I would say, Leslie, the same thing I say when I'm in court. If I had a client who had dementia, right, and one of the features of dementia is a lack of insight into the illness, and they live in a hoarding situation, a dangerous environment, they don't eat food that's fresh, they live with rodents, they are unclean, they have urinary tract infections, they're, bed sores. We as a society don't turn our backs. We make a value judgment and say that person has a medical condition that prevents them from knowing what's right from wrong. And we regularly pull those people out of their homes, put them into nursing homes or other involuntary treatment in their best interest, right? To me, when I go to court, I make those same exact arguments. When I'm working with a mental health case and a judge is trying to tell me it's not the same, I say, how can you differentiate? If I told you nothing about the diagnosis and I told you only about how they lived and what their functional limitations were, you would give me a guardianship order every time. It's only when I tell you that's by virtue of a mental health issue that you balk at that suggestion. But ultimately, those two people are the same people. And so, having worked many years with the elderly and people who are infirm in that way, I just try to keep phrasing it from a medical perspective of this is an infirmity and it's heartless and irresponsible to leave people living like that in any circumstance. We wouldn't do it with children. We don't do it with toddlers. We don't even do it with kids who are 16 or 17. We have control over those circumstances, and I don't see the differentiation. And I think it's ignorance when people are raising those issues. If we were guided by everybody's traumatic experience, we would make no progress ever anywhere. And that's just not reality, and the only way to change the number of people who might experience that trauma is to get to them sooner so they don't even have to be in those inpatient settings. And by ignoring that, we're just assuring more people will be subject to that treatment. That's it. It's that straightforward.
Wow.
Thank you,
Well,
Laura. Appreciate your
this was
work.
a lot of information, and you packed it in
Yeah.
less than an hour. So
Well, I'm always here, Paul. I'm happy to come back or answer any other questions. You have my email. You can distribute it to anybody. I'm always happy to answer questions.
Well, Laura, thank you very much. I
You're
really
very
appreciate you
welcome.
coming here
My
today.
pleasure. Really
Thank you
nice to meet
so
you
much,
all.
Laura.
Take care. My pleasure. My pleasure. I'm wishing all of you the best.
Same
Thank
to you.
you. And thanks, Paul.
You're welcome. Okay,
Bye.
talk to you soon. Bye.